Hi guys, and welcome back to Legal Risk Evaluation and Systems. And this week we are up to week 9, which is the risk inherent in litigation and disputes. And here we have a rather interesting chapter in the text. Despite neither Whaley nor Ghazalian being hard-nosed litigators, we have a chapter that looks quite carefully at the nuts and bolts of the litigation process. And they try to quarantine their discussion to a fairly restricted area. Perhaps that's because of their qualifications. I'm not sure if someone guest wrote the chapter. But they say they're only going to focus on things that can go wrong in the litigation process that may well compound the losses or cause the organisation to sustain further losses. And so they go into, like I said, a fairly detailed discussion on things like privilege, process, establishing the facts of the case, establishing the strength of the legal arguments, working out exactly what it is that is under dispute between the parties. They have a little look at witnesses, they look at judges, they look at courts, and they also have a look at things like disclosure. Not surprisingly, given their penchant for hard data, they rather inevitably move forward to a discussion of, how can we quantify all this? Well, what's most important to the business? The success of the litigation. So let's try and work out some kind of formula, some kind of rather objective sounding method to predict the outcome of the case. And I think that's, it's a nice insight into the particularities of the litigation process. But you'll see that I have placed in the readings for you an excellent video by a lady called Sherry Farrell, who is a prominent US trial lawyer, and she really speaks from a wealth of experience in this area. I mean, I certainly don't profess to be any kind of expert in litigation, but you can pick up the flavour of what's really important in terms of risk management in an overall sense from Sherry's video. So I would strongly recommend that you guys watch it. It's only about 20 odd minutes long. But I just from that video wanted to pick out what I saw as kind of her 7 top tips for litigation risk management. And I really like what Sherry Farrell has to say, because given her wealth of experience with the nuts and the bolts that Whaley and Ghazalian talk about in their chapter, she then has the wherewithal to step back and look at all of that in an enterprise-wide fashion. And that's what I think really sets her discussion apart for our purposes, because this is the kind of viewpoint we need to going to pick up on, more of a bird's eye view, in terms of marrying together the business's operations and the whole litigation strategy that's engaged in by the organisation. And the first top tip that she has for us is that anticipation is the key. And I think that is just so true, not just in terms of litigation, pretty much for everything, because risk management is all about anticipation and then putting in place strategies, processes, systems in order to manage the identified risks that may crop up. So not surprisingly, her first top tip, anticipation and preparation are key. And she uses this analogy, don't be the rock that's rolling down the hill, being pulled towards a rather terrible fate at the bottom, purely by gravity. You want to make the decisions up the top, and you want to control how things proceed further down the track. The second thing that she talks about, and this is where she begins her enterprise-wide kind of discussion, focus on the whole enterprise. And she does talk about this issue of, you know, legal departments and lawyers often being seen as just the silos that operate according to their own rules and procedures, and they sit in their ivory towers, and they, you know, every now and again flick a few crumbs of information out to the organisation, but apart from that, they're really an irrelevancy. She says you've really got to marry the organisation together with the legal department. She says to bring the whole enterprise on board as a partner. Sounds a little ambitious, but certainly it has worked for her. She says you need to align the litigation and business strategies by ascertaining the business intentions, ascertaining the business priorities, looking at the litigation reality, the processes and so forth that need to be engaged with, and then developing your litigation strategy in light of the business strategy overall. And I think that's really important. As part of that, she says you've got to understand that there's this constant tension between the litigation cost and the litigation benefit. And she says that you need to be able to be prepared to defend your position on the benefits of whatever litigation that you are recommending proceed forward. You need to always bear the enterprise business strategy in mind when you are making decisions about what litigation is going to move forward and what will be settled and what will not. Okay, so the third top tip she has for us is ensuring that your litigation processes are transparent. And this follows very nicely from her point about legal departments being seen as silos. We don't want that to happen anymore. We want this partnership arrangement between the whole enterprise as well as the legal department. She says the C-suite needs to understand what impacts litigation will have on the company in terms of cost, in terms of time. And she says particularly where you've got to drag people out of their offices for depositions, you know, you've got them appearing as witnesses at trial. She says the disgruntled nature of the employees in having to do this for the organisation will be toned down significantly if everybody knows from the top down what are the impacts that the litigation are going to have on business, and everybody knows this up front before the decision is taken to actually move that litigation forward. The fourth tip, she says, is keep track of numbers. And this is something that we certainly know about from our excursions with Whaley and Gazzellian, don't we? We need to document, and we need to tabulate and create databases so that all of the information is readily accessible. It's information that can feed into not just a reporting cycle, but also the decision-making cycle moving forward. Okay, she says management requires measurement. And again, that's something that we certainly have heard from Whaley and Gazzellian. She says, decide on your data points. What are your data points going to be? Your number of cases, your cost, the jurisdiction, you know, whether things have settled or not settled. Give a quarterly snapshot of litigation trends and costs. And then importantly, again, she ties that back to an enterprise-wide viewpoint. And she says, take that data, correlate it with the business strategy, map it out so that you can show the C-suite, you can show the board, this is how our litigation strategy aligns with the business's strategy, and these are the improvements that are being made to more closely align the litigation strategy with the overall organisation strategy. The fifth tip, she says, is, and this is something we've looked at just a couple of weeks ago, pay attention to risk management, corporate governance, and compliance. Again, document, document, document. But here she's talking, rather than numbers, she's talking about document your processes, document your procedures. Keep track of whatever regulatory requirements that apply to your particular area, the dockets that you might have, and record your compliance with the regulatory requirements. Know your employees disputes, know your corporate culture, know supplier issues. All of this kind of familiarity with your organisation is going to feed into your assessment of how likely or not there will be risks inherent within the organisation that you need to keep track of. Okay. The next tip she has for us is create business intelligence around the litigation process. And here she's talking not so much about the numbers issue, but more about the practical nuts and bolts of things. So she's saying once you've got your numbers, once you've got your data, you can go back, you can look at it, and you can say to yourself, how have we gone in this particular jurisdiction? Have we been quite successful? If we have, what makes that jurisdiction any different to any other jurisdiction? Is that success transferable? Is it not? Do we need to amend our processes in the other jurisdictions to try and emulate the success that we've found elsewhere? She said, ensure your processes are defensible and repeatable. And if they are, you can then map an informed preventive cycle. You can look at patterns and you can put in place preventative measures for anything that might be going wrong. She then moves to a more Whaley and Gazelian-like discussion of case level issues, and she says to use the litigation risk assessment as a framework. So use that to inform your design of litigation strategy for the organisation. Start with your goals, move towards what kind of action that you need to achieve the goals, and implement an intentional strategy. Okay, again, you're not going to be able to do that unless, harking back to tip number one, you've anticipated the things that might go wrong, the things that might go right, and then you can formulate your strategy intentionally from there. Interestingly, she says it doesn't really matter, how much or little the case, the potential litigation is worth, but she's saying unless it's very, very low risk to the organisation, she always does an initial case assessment with an external counsellor. And I think this is fairly sage advice given, particularly in the US, the vagaries of the litigation system and the differences, the incredible differences that you have just from one state jurisdiction to another. So she says that's certainly a worthwhile investment. Once you've got that in place, you can then decide at an organisational level the direction that the litigation will proceed, trial, no trial, how are we going to deal with trial if we're going to move it forward. And then she talks about some minutiae, so, make sure that in terms of discovery, you've got an efficient search mechanism, you've got well-defined roles, and you've managed your risk appropriately there. I don't want to labour the points, but I think I've given you the headings in Sherry Farrell's video that will enable you to pick out from that video the gems that she's got for us, because I really do think that it's a very worthwhile resource for us, and it does tie in an overall enterprise level view with the text's more technical discussion of the litigation process. So have a look at the Sherry Farrell video, and as I always say, if you've got any queries or questions, please drop me an email or post something in the forums. I hope you enjoyed the video. If you did, give it a big thumbs up and subscribe. And I look forward to chatting with you sometime soon in a Zoom. Until then, thanks for watching. Bye, guys.